Big tech against the national security. Supreme Court looking into a case involving your privacy and Microsoft. The Supreme Court hearing arguments in a high-stakes case pitting digital privacy against our national security. At issue, whether Microsoft must comply with a warrant from federal agents to turn over emails they suspect were used in drug trafficking. Now, Microsoft stored the emails on a server in Ireland, and they claim the emails are beyond the warrant's reach, despite the company's headquarters being, of course, in Washington State. Here now to discuss former federal prosecutor Doug Burns and Varghese, a criminal defense attorney and former prosecutor himself. Vanu, let me start with you. I mean, golly, I guess the technicality of it, that they're located physically somewhere else, is one thing. And we've seen this over and over again with encryption and certain data that these tech companies have and they won't share with law enforcement. So where do you see this going?
I think the first thing is how interesting this case is, because this is really an application of the America First doctrine. This case was started by the Office of Preet Bharara, who was appointed by President Obama. But yet the Justice Department is still continuing on this track. And what they're trying to do is get these emails from abroad. And this is really extending and going beyond what the law allows. Now, if Congress changes the law, then they should be able to get this stuff.
We should note that there is a bill making its way through Congress called the Cloud Act. Right. And the major tech companies back that. And I don't know all the intricacies of it, but some say it could alleviate this particular issue. At least the tech companies are going to the Supreme Court and say, hey, this shouldn't, don't let the courts handle this. We should have a legislative answer to it.
Well, those who are watching this case, Charles, are saying that this is a classic example, and I agree, of the law having to catch up with technology. When the original law was passed, the Stored Communications Act in 1986, you didn't have the type of internet activity. On the case itself, Vanu's so right. It's really interesting because in the Second Circuit, they had a rehearing en banc, the whole court, and they were split 4-4, leaving in place the first decision, that had been reached. So it's going to be close.
What was the first decision?
The first decision was in favor of Microsoft, saying that the subpoena, the warrant, was beyond the scope of the U.S. But I think the Supreme Court may go the other way.
Yeah. Do you handicap? How would you handicap it? A potential outcome?
I would like to think that they would rule in favor of Microsoft, because I think the problem here is that if it rules in favor of the government, what's going to prevent a foreign nation from demanding property in the United States, from requiring, for example, if what's going to prevent Russia?
It's not physical property, though, is it? I mean,
it's where the actual data is stored. So Microsoft uses data and they store locally.
But there's a big wrinkle on it, sorry to interrupt, which was that both Justices Kennedy and Justice Alito said, wait a minute, you can access this in 5 minutes with a couple of keystrokes here in the U.S., and you're a domestic company. Look, it's a close case, but again, telegraphing what the justices were saying, I would think that they may go the other way.
Does the fact that it may impact national security or individual safety, does that weigh on this at all, or that has nothing to do necessarily with the interpretation of the law?
That's the argument the government is making, that this would hamper law enforcement efforts. But this was a drug case. This is a narcotics trafficking case. This is not a national security case that this subpoena.
But what if it was a terrorist and they had some information offshore locked in that could stop potentially a terrorist attack?
Well, what they're doing, what the government, and with the bill you mentioned, is supposed to have carve-outs for this. Even the Stored Communications Act has certain carve-outs for emergency exceptions. So that wouldn't affect this case.
Right. The other argument, real quick, is that we have what we call mutual legal assistance treaties, MLATs. So the argument is just go through the MLAT to the Irish government and get the material. So
it's obviously something went wrong, or it wouldn't have made its way to the Supreme Court. Gentlemen, thank you both very much. Appreciate it.
Coming up. Thank you.